discusses the federal system in detail, including a brief history of the system and an outline of the federal employees' compensation benefits available. In addition to the federal compensation system, the chapter also discusses the federal Black Lung Program, Social Security, Medicare, Medicaid, as well as explaining the Defense Base Act. In this chapter, we'll examine the various federal programs that protect employees and also summarize the benefits that each provide. Now, these programs, such as the Federal Employees Compensation Act, the Federal Black Lung Program, and the Defense Base Act, provide benefits to folks who work in various capacities for the federal government. Now, before we examine the specifics of those programs, we must first take a look at the options available to employees before these acts were created. In Chapter 1, we discussed the development of workers' compensation insurance and how it developed as a direct response to the Industrial Revolution and the fact that workers who were injured on the job had no real legal recourse because of the overwhelming bias towards employers in tort law. In Chapter 2, we're going to take a look at the venues available to injured workers prior to the enactment of some of the state and federal workers' compensation systems. When we talk about civil law, you may remember from some of your other classes that tort law, or civil injuries, or as some people call it, personal injury law, is the most often practiced area of the law. Within that subsection of civil law, negligence is the most common form of tort action or personal injury action. So negligence is, suffice to say, an important area of the law for you to understand. If you consider the frequency with which persons injured in car wrecks and slip and fall accidents and situations like that sue each other, you understand why there's so many cases involving negligence. But negligence, while it works well in some other areas of personal injury law, doesn't really lend itself well to workers' compensation law. You either have learned or will learn in your civil injury class that the basic elements of a negligence suit are duty, breach, causation, and damages. And then in order for a claim of negligence to stand, each one of these elements must be proven. Let's take a brief look at each one of these elements as it applies to workers' compensation law. Now remember that a plaintiff in a negligence action, and a plaintiff would be the injured party, has to establish that the defendant owed the plaintiff a duty. So for instance, if you're driving down the street, you have a duty to be careful not to hit pedestrians. If, however, you look down to text on your phone or grab a pen off the floor or something, you may have violated that duty to act in a careful, reasonable manner when you hit a pedestrian. So when you apply this to a workers' compensation situation, the worker or the injured party would have to establish that the employer had a legally recognized responsibility to provide safe working conditions. We'll take, for instance, a situation where you're working with heavy equipment, or an employee's working with heavy equipment. In that situation, the employee knows going in that this is sort of an inherently dangerous job situation to be in. So in this case, the employer might raise the defense of assumption of the risk. In other words, the defendant, the employer in this case, can show that they didn't violate any duty to the plaintiff because the plaintiff knew going in that the job they were going to engage in was dangerous, and they chose to expose themselves to that danger. So if the defendant can prove assumption of the risk, it's essentially a defense to a negligence claim. And if the defense is accepted, the negligence claim is then dismissed. So that leaves the employee with a tough choice, right? The employee is faced with the choice of continuing to work and assuming the risk, or quitting and going to work somewhere else. And now you can start to see some of the problems inherent in not having a workers' compensation system and leaving employees open to this claim of assumption of the risk, and thereby being responsible for injuries incurred on the job. Product liability is another way that injured employees would try to get redress for their injuries, again, prior to any workers' compensation statutes. And product liability is different than negligence in that it doesn't require a breach of some duty on behalf of the employer. It simply assesses liability against a manufacturer or seller or a wholesaler for placing a dangerous or a defective product on the market, and that product causes an injury or damage to the employee somehow. So in a typical situation, let's say that a food manufacturer puts together some type of processed food, puts it out on the market, and they let it get tainted with some bacteria. The end consumer eats that food and ends up getting sick because the seller, the manufacturer, the wholesaler, put that defective product on the market, and the end user was ultimately injured by it. We have a products liability case or situation. So how do we apply this to a workers' compensation situation? If a worker's on the job and injured by a product, they may bring an action against the manufacturer of the product that caused the injury. However, the obvious disadvantage of only being able to rely on the product liability for an injured worker is that not all injuries are the result of defective equipment. In order to win in this type of suit, the employee has to prove that the product caused an injury, that the injury was foreseeable, and that the product was placed into the stream of commerce and was therefore available to consumers. Another theory of tort law is intentional torts, intentional versus negligence, the first thing we talked about. A person commits an intentional tort when he or she deliberately injures another person. For instance, if you walk outside and you punch somebody in the face, you've committed the tort of battery. Incidentally, you've also committed the crime of battery, but torts and crimes are two different areas of the law. Torts is the civil side, and criminal law, obviously, the criminal side. So, how does this apply to workers' compensation? Well, intentional torts by co-workers is where we normally see this. A co-worker injury, an injury caused by a co-worker, falls outside the normal prohibitions in workers' compensation cases. Remember, if you're injured as an employee, you have that exclusivity of remedy, which is the workers' compensation system. However, if you're injured by a co-worker, you still have the ability to sue in a civil court that co-worker on the basis of intentional tort. All right, let's move on to federal workers' compensation. Remember, in Chapter 1, we discussed the general characteristics of the state-based workers' compensation systems. And we saw that each state had a slightly different system based in part on previously existing laws and the models workers' compensation codes available. In this chapter, we're going to examine the elements of the federal workers' compensation system, which has features that differ sharply from the state-based systems. And one of the major differences is employees that are covered. If you work for a private employer, or you work for a municipality or a state or a city within a state, then you're covered by the state compensation system. If you work for the federal government, then you are covered by the Federal Employees Compensation Act, or Federal Workers' Compensation. Now, the chance of a workers' compensation claim involving a federal employee is pretty high, the chance that you're going to see one when you're out there working in a law firm. After all, the federal government is one of the largest employers in the nation, and especially around our area, with all of the government offices and military offices, the chances of encountering one of these claims is pretty high. Federal workers' compensation is covered by the Federal Employees Compensation Act. And under the FECA, federal employees who are injured on the job are entitled to payments not only for medical and surgical costs, but also for rehab and other costs. And the U.S. Department of Labor Office of Workers' Compensation Program is the body tasked with administering FECA. The Federal Act was created in about 1916 and predates a lot of state systems. It's not only older than most state programs, it's also more liberal. And the federal system was developed at a time that the federal government was breaking up huge business monopolies and taking away some of the monopolies held by the so-called robber barons. Now, remember what was going on in the early 1900s. It was a time of great social unrest, and a lot of the workers in both private and public institutions were complaining about working conditions. And the federal government was beginning to pay greater attention to business practices by major corporations and sort of got out ahead of this workers' compensation system by developing the federal system again in 1916. So the definition of who qualifies as an employee under FEC is relatively straightforward, and it's found in 5 United States Code annotated section 8101. The definition basically says that if you work for a branch of the federal government, or if you work for the District of Columbia government, then you are a person qualified for federal workers' compensation benefit. Now, you may be wondering why District of Columbia is set out there. Remember, the District of Columbia, Washington, D.C., is not an individual state. It's a separate and distinct district which is sort of parented by the federal government. While there are some exceptions to those two simple rules of who qualifies, the courts take the approach that they assume that a person is covered under FECA unless it's proven that they're covered under some other federal statute. What they're trying to do is make sure that federal workers don't fall through the cracks. So essentially, although exceptions do exist, the Act presumes coverage unless proven otherwise. One of the major differences between state workers' compensation systems and federal workers' compensation systems is the rate of pay that the employee receives while they are not able to work because of the injury or illness. In Chapter 1, we talked about the concept that in a state compensation system, benefits are paid according to classification. In other words, if they're temporary or permanent, and also whether they're temporary partial disability or temporary total disability. Federal system, a little bit different, a little bit more simple, sidesteps those classifications, and benefits are paid at a rate of 2/3 of the employee's normal salary unless the employee falls into the category of a traumatic injury, in which case they'll receive full payments for at least 45 days, followed by a payment of 2/3 of the salary for the rest of the illness or injury period. One of the benefits under the federal system is COP, or continuation of pay. This would be the counterpart in the federal system to temporary and permanent benefits available under the state systems. Now, the determination of continuation of pay lies with the administrative board that oversees the FECA system and is based on a few important factors. Essentially, when an employee receives COP, the employer must continue the employee's regular pay until it controverts COP for any of the following reasons. And these reasons include things like the employee's caused the injury to himself or herself, was injured while using illegal drugs, decides to continue working without receiving COP, and so on. There are several basic elements that an employee must show in order to be able to file a claim under FECA. They have to show that they're qualified as an employee, as that term is defined under the federal law, that they were performing their job duties at the time of the injury, and that the condition is a direct result of the injury sustained on the job, which just makes sense, right? Another important step, as you might expect in a federal bureaucracy, is that the employee fill out the right forms. If you look on page 38, 39, and 40 of your book, you'll see one of the reports that the employee has to fill out. An interesting and important point here, under federal law, an employer, this is a federal employer, can be criminally punished for failing to provide medical attention to an injured employees. Now, there are some other federal programs that provide coverage to employees, such as the Longshore and Harbor Workers' Compensation Act of 1927, the Federal Black Lung Program, and the granddaddy of them all, of course, Social Security. And I want to take some time and explain to you the basic arrangement of Social Security and the benefits available, and we'll explain a little bit about how these benefits interact with an injured worker's payments under the workers' compensation system. Remember, Social Security hasn't been around forever. It was enacted in 1935 as a part of FDR's New Deal, and it was essentially a financial safety net for people who had grown too old to work. We all know that part of our paychecks every month or every couple of weeks go into a supplemental security income fund. Social Security is significant in any discussion about workers' compensation, not because of payments made to individuals over a certain age, which is how most of us think of Social Security, but because of the other part of Social Security that figures prominently into the workers' compensation discussion. Now, in addition to providing a measure of financial security to people who have retired, the Social Security Administration also provides disability insurance, so-called SSDI. SSDI is available for individuals who the Social Security Administration determines are no longer able to return to work. If so, they'll receive regular payments referred to as supplementals. SSDI, like other insurance programs, are only available to individuals who have actually paid into the system. Now, to differentiate, SSI, or supplemental security income, differs from SSDI, which is disability income. SSI is the payments received by retired persons, disabled persons, and others. SSDI refers to payments made to people who are unable to work for 12 months regardless of their age or disability. Now, in addition to Social Security, we also need to talk about Medicare and Medicaid. These are two other vitally important government safety nets for injured workers and may provide additional benefits in addition to those received through either state or federal workers' compensation systems. Let's talk about each one of these individually. Medicare is a national insurance program for particular groups of people, including those who are over 65, those who have disabilities, and those who suffer from kidney failure. Medicaid, on the other hand, is run by the states, and as a result, the rules about who qualifies are governed by the states and vary from state to state. It's designed to provide medical care to the nation's poorest people and is by far the biggest medical program in the United States. There are 25 different qualifying eligibility criteria for Medicaid, but the 5 main categories deal with pregnant women, children, adults who meet certain income limits and have dependent children, persons with very specific disabilities, and people who are 65 or older. And one of the biggest issues you run into is that people think Medicare and Medicaid are the same thing, and as we've seen, one is federal, one is state. They're very different. The only reason they're usually discussed at the same time is that they focus on the same thing, which is medical care for a specific group or groups of people. Technically, a person can receive benefits from Medicaid, Medicare, Social Security, disability insurance, and workers' compensation benefits all at the same time if they qualify. Now, typically, CMS, or Centers for Medicare and Medicaid Services, is a federal agency that is supposed to ensure that an injured person receives a fair share of compensation but doesn't get double or triple awards for the same injury. Now, like it or not, there is fraud involved in all of these programs, and therefore all of these programs have criminal enforcement provisions that allow them to bring criminal actions against people who have defrauded the federal government. They can also bring civil suits against people who have received more than their fair share of benefits. Of particular interest to those of you in the paralegal program may be that Social Security, Medicaid, Medicare benefits, when people are denied coverage, they can hire a non-lawyer to represent them at hearings. And paralegals and other non-lawyers routinely represent clients at these administrative hearings. Non-lawyers, like paralegals, are permitted to charge fees. However, the government must approve these fees. They can't be exorbitant. They have to be reasonable. One of the last federal programs I want to talk to you about is the Defense Base Act, which was created in 1941, as you might imagine, with the proliferation of the military bases, as a way to supplement coverage for workers on military bases outside the United States and its territories. Essentially, the DBA provides a broad umbrella of benefits that are very much like workers' compensation benefits under either a federal or state program, in that they provide disability payments, medical payments, and some death benefits. So who's covered under the DBA? Employees working on military bases outside the United States or the territorial limits of the United States, employees carrying out a U.S. government-funded public work project, carrying out public works projects with foreign governments, and providing services funded by the United States that fall outside the normal activities for regular military employees. So that brings us to the end of Chapter 2, and again, this chapter is about workers' compensation being a system that developed outside the normal civil actions available to an injured person because of what was going on in industry at the time of the turn of the century. Unlike negligence cases where an injured person must establish duty, a violation of that duty, causation, damages to workers' compensation situations don't assign blame. It's a no-fault situation. It's a no-fault program. In a negligence case, an injured employee would be at a distinct disadvantage in bringing such an action against an employer. And this is one reason why workers' compensation system acts as a no-fault system. Injured employees are not required to sue employers in order to receive benefits. In fact, in order to qualify, an employee must waive his or her rights to bring civil action against the employer. However, it doesn't mean that an employee waives all rights. They can, for instance, bring product liability and intentional tort actions against employers or fellow co-workers who may have caused injury to the employee. The federal workers' compensation system, created in 1916, generally more liberal in its application than most state systems. Under the FECA, an injured employee is entitled to continuation of benefits equal to 2/3 of his or her salary. Other federal programs such as federal black lung program, Social Security, Medicaid, Medicare, all provide other benefits for people who have been injured. Most of these federal programs work in conjunction with one another and in conjunction with based workers' compensation system. The idea is to ensure that a person doesn't receive a windfall of unearned benefits. That's Chapter 2. When we meet again, we'll talk about Chapter 3. Hope you have a great day, and as always, contact me if you have any questions.